Hi, I'm Jim Fletcher, an estate planning attorney here in Georgia. If you've ever wondered whether a will needs to be notarized, you're not alone. This is a common question I get from clients. So today we're going to clear it up. The short answer is no, a will does not have to be notarized to be legally valid in Georgia. But there's a little more to the story. And I'll explain why a notary is still important when signing your will. But first, let's cover the basics of what makes a valid will in Georgia. There are 5 key requirements. So 1, the person who makes the will, we call them the testator, needs to be at least 14 years old. Georgia actually has the lowest minimum age in the country to create a valid will. Number 2, the testator has to be of sound mind, so they can't have been legally declared incompetent. Number 3, the will has to be written. Spoken or oral wills are not valid in Georgia. They can be typed or handwritten, but it has to be in writing. Number 4, the will has to be signed by the testator. They have to put their signature on the document to make it official. And 5, the will has to be signed by 2 witnesses. The witnesses have to be at least 14 years old themselves. Here's where the notary comes in, not for the will itself, but for something called a self-proving affidavit. Let me explain. In the past, when someone passed away, their witnesses had to show up in court and testify. Yes, I was there, I saw them sign this will, that's their signature. But over time, attorneys realized, what if the witnesses passed away themselves, or they moved out of state, or you can't find them? That's where the self-proving affidavit comes in. It's a one-page document that just says the same thing the witnesses would say in court. We were there, the testator was of sound mind, they were over 14, we saw them sign it. So the testator signs the affidavit, the witnesses sign it, and then it's notarized. And that makes the will self-proving. So when it comes time to go to probate, the court doesn't have to track down the witnesses. Everything's already verified. I can't tell you how often people bring in a will from the 1960s. It's technically valid, but it has no self-proving affidavit. We might be stuck trying to hunt down witnesses from years ago. It might be impossible. So while you don't need a notary for the will itself, you definitely want one there when you sign, and we need a self-proving affidavit. It's one small step that makes a big difference when the time comes for your family to carry out your wishes. If you're not sure if your current will has a self-proving affidavit, or if you just need to update your estate plan and make sure everything's in order, I'm here to help. Give me a call at 404-409-5665. Visit me at FletcherEstatePlanning.com. If you don't mind, if you liked this video, please hit the like button below. The more likes we get, the better we can share this information with others. I'm Jim Fletcher, and I'll see you next time.